There are 6 critical documents that every American homeowner over 60 should have on file, yet most never even hear about them. And when they pass away, the lack of these forms often ends up costing their children the family home. I am going to walk you through each of these documents one by one. I will explain the exact clear-throat amount of money each one can save and the precise order you should put them in place. The 5th document on this list is the one that 9 out of 10 seniors do not learn about until it is too late, until their children are already sitting in a probate courtroom watching a judge decide who walks away with their parents' house. We are going to cover that one shortly. But first, you need to see why this problem exists in the first place. The American probate system was never built to protect families or honor their wishes. It was built to generate income for state courts and steady fees for the lawyers who operate inside that system. As a result, every year, hundreds of thousands of families in this country lose tens of thousands of dollars, sometimes the entire value of a home, simply because the people who designed the system never told them about the 6 documents that could have prevented it. Most of these forms cost under $200 to put on record. A few are completely free. But if you do not know they are out there, the system quietly absorbs the money you meant to leave your children, and after you are gone, your family has no way to reverse it. Here are the 6 documents and the sequence you should file them in. The first document is the difference between your children writing a check for $20,000 and paying absolutely nothing. It is called a transfer on death deed, often shortened to TOD. This document has a single job, but it is the single most crucial item in this entire list. It lets you name the person who will receive ownership of your home the moment you die, without that property ever entering the probate court process. Here is why that is such a big deal. The typical probate case in the United States costs a family between 3 and 7% of the total value of the estate. On a home worth $300,000, your heirs are paying somewhere between $9,000 and $21,000 in court costs, attorney bills, and executor fees before they ever get the title. But even that bill is not the worst part of probate. In certain states, the probate timeline runs anywhere from 9 to 18 months before it is finished. During that entire period, your family cannot sell the house, cannot refinance it, and often cannot even clear it out. Property taxes continue to come due. Homeowners insurance still has to be maintained. If there is a mortgage, those payments keep going as well. All of that money has to come from your children while they wait around for a court to tell them they are finally allowed to handle their own parents' home. A transfer on death deed eliminates all of this. You record it once with your county recorder, and on the day you pass away, the property moves directly to whoever you named on the form. There is no judge, no attorney bill, and no waiting period. Transfer on death deeds are currently available in roughly 30 states. To find out whether your state is one of them, search the phrase "transfer on death deed" plus the name of your state. In most counties, the cost to record this form ranges from $20 to $60. But the transfer on death deed only does its job if it is recorded before you die. Most families learn about it too late. That is why this is not a document you push off until sometime next year. The second document is the one the federal government would prefer you never hear about. It is called a ladybird deed. This deed exists only in 5 states: Florida, Texas, Michigan, Vermont, and West Virginia. If you live in any one of those 5, you need to focus carefully for the next 60 seconds, because this single piece of paper can shield your house from a threat that financially destroys families every day in America. Here is what a ladybird deed does. It allows you to keep total control over your home while you are alive, including the right to sell, refinance, or rent it, while automatically transferring the property at your death to whoever you name on the deed. It operates almost exactly like a transfer on death deed, with one crucial difference. A ladybird deed protects the house from Medicaid estate recovery. I covered the Medicaid 5-year look-back rule in another video, but here is the quick version. If you ever apply for long-term care Medicaid toward the end of your life, the federal government is allowed, after your death, to force the sale of your home in order to recover the amount Medicaid spent on your nursing home care. For a typical 3-year stay in a nursing facility, that is usually between $240,000 and $360,000 the government can claim from your estate. This is how many families lose everything they hoped to pass on. A ladybird deed removes your house from your estate at the exact moment you die. Because of that, there is nothing left for Medicaid to pursue. Your children receive the home without any Medicaid repayment attached, even if you spent your last 5 years relying on Medicaid. However, this only works if the ladybird deed is signed and recorded before you ever apply for Medicaid. If you wait until after, the 5-year look-back rule wipes out the protection. So, if you live in Florida, Texas, Michigan, Vermont, or West Virginia, and you own a home, this is a document you should be discussing with an estate planning attorney this month, not at some vague point in the future. By the time you realize you need it, the opportunity is usually gone. The third document is the one that, over time, saves families more money than any other item on this list. But it is also where people make their costliest mistake. It is called a Revocable Living Trust. Setting up a trust is more expensive than the first two documents. You are looking at somewhere between $2,500 and $3,000 in legal fees depending on the attorney you work with. But here is why the cost is worth it. When you move your home into a revocable living trust, you are no longer the owner on paper. The trust is. You still have complete control. You can sell the house, refinance it, move to a new place. Nothing about your day-to-day life changes. But because the property is technically held by the trust, it does not count as part of your estate when you die. That means probate cannot touch it. On a $400,000 home, this single step saves your family between $12,000 and $28,000 in probate expenses alone. More importantly, a revocable living trust lets you lay out clear, detailed instructions for what happens to the house when you are no longer here. If you have 3 children, one of whom lives in the house while the other 2 want to sell, the trust can spell out exactly how that situation should be handled. If you want your surviving spouse to stay in the home for the rest of their life and only then pass it on to the kids, a trust can enforce that. If you want to protect the house in case one of your children later goes through a divorce, a trust can help guard against that as well. A traditional will cannot accomplish any of these things. A will gets read in court, and at that point, a judge makes the final call. A trust, on the other hand, stays private, bypasses the court system completely, and does exactly what you wrote into it. Here is where families unknowingly erase the benefits they just paid thousands of dollars for. The most costly mistake people make with a trust is signing all the paperwork, but never actually moving the house into the trust. The technical term for this is funding the trust. If the trust exists only on paper while the deed to the house still lists you personally as the owner, then the trust is effectively useless. The home still ends up in probate, and every dollar you spent setting everything up is wasted. So when you finish creating a trust, the very next step is recording a new deed that transfers the property from your individual name into the name of the trust. Skip that step, and your trust might as well not exist. We are now halfway through the 6 documents, but the 5th one, the one almost no one has heard of, is still coming, and it is the document that can save your family the most while giving you the smallest window of time to act. Stay with me. The 4th document is an updated will that includes clear, specific language about your home. If you die in the United States without any will at all, your state's laws decide who gets your property. This is called dying intestate, and the rules do not work the way most people assume. In Texas, for example, if you pass away without a will and you are married, your surviving spouse receives only 1/3 of your separate property. The remaining 2/3 go to your children, even if those children are from a previous marriage and barely know your current spouse. In California, if you die intestate and have children, your spouse only gets 1/3 or 1/2 of the community property, depending on the details of your situation. In Pennsylvania, the first $30,000 of your estate goes to your spouse, and anything above that amount is divided. These intestacy rules are different in every state, but the pattern is the same nationwide. The state assumes it knows how your assets should be split, and without a valid written will to override those statutes, the state's plan wins every time. The solution is straightforward. A simple will usually costs between $200 and $800 when prepared by an attorney. Some online platforms offer will templates for under $100, but if you own real estate, I do not recommend the bargain online versions because the wording related to property has to comply with the specific laws in your state. Here is the part almost everyone overlooks, And this is the part that causes bitter family disputes. A will must be updated whenever there is a major change in your life or family. If you signed your will back in 1992 and have not opened it since, there is a good chance the information is wildly out of date. Your spouse may have passed away, your children might have gone through divorces, grandchildren could have been born, the executor you originally named may no longer be alive or able to serve. Because of this, every will should be reviewed at least once every 5 years and after any major life event. An outdated will can be more damaging than having no will at all because it sends your family into court arguing over which version counts. And during that fight, the house just sits there, draining money. Now we come to the fifth document, the one I mentioned earlier that almost no one knows about. It is called a durable power of attorney for finances. This is the form that 9 out of 10 seniors never sign, and it is the one that ends up costing their families the most. If you only take action on one document after watching this video, make it this one. Here is why. A durable financial power of attorney is the document where you name someone you trust to handle your money and property if you become unable to manage them yourself. If you have a stroke, develop dementia, or land in the hospital for an extended stay, this is the paper that allows your spouse or one of your children to pay your bills, access your bank accounts, and, most importantly, take care of anything related to your home. Without a durable power of attorney, your family cannot legally do any of this. They cannot access your accounts, they cannot pay your mortgage, they cannot sign documents to sell the house, refinance, or even authorize repairs. Their only option is to go to court and ask a judge to appoint a guardian or conservator over you. This process is called a guardianship proceeding. In the United States, the average cost of getting a guardian appointed runs from $3,000 to $10,000 in legal fees. After that, the guardian usually has to file yearly reports with the court, which can add another $2,000 to $4,000 per year in ongoing costs. But again, the worst part is not the bills. It is the time lost. A guardianship case often takes 3 to 6 months to finalize in most states. During those months, nobody is legally allowed to pay your property taxes, sign for necessary home repairs, or sell the house if you need to move into assisted living or a nursing facility. Nothing can be done, but the payment due dates do not pause. The mortgage company is not going to delay foreclosure just because your family is waiting on a court order. That is why homes are lost to foreclosure in the middle of guardianship cases every year in this country. And in each of those situations, one simple document signed on an ordinary Tuesday afternoon would have prevented the loss completely. A durable power of attorney for finances typically costs between $100 and $300 when drafted by a lawyer and usually takes about an hour to complete. But here is what makes this document so urgent. It must be signed while you are still mentally capable of understanding what you are signing. The instant a doctor notes that your mental capacity is in question, the opportunity to sign a power of attorney disappears. You cannot create one from a hospital bed after the fact. Your children cannot sign it on your behalf. Once that line is crossed, the only remaining option is a court proceeding, and by that point, much of the damage is already in motion. The sixth and final document is your homestead exemption application. This is the one quietly costing you money right now, today, and every month you go without it. Nearly every state in the U.S. offers some form of homestead exemption to homeowners, but the rules and savings vary dramatically from one state to another. In Florida, the homestead exemption removes up to $50,000 from your home's taxable value for property tax calculations. It also limits how much your property tax bill can rise each year, no matter how high your home's market value climbs. In Texas, as of 2024, the homestead exemption knocks $100,000 off the taxable value of your home for school district taxes alone. The yearly savings differ by location, but for most older homeowners, the benefit usually falls somewhere between $1,000 and $3,000 per year. Over a 20-year retirement, that adds up to between $20,000 and $60,000 staying with you instead of going to your state or local government. Here is what many seniors do not realize. In a lot of states, the homestead exemption is not automatic. You have to submit a form to your county tax assessor's office to claim it, though you typically only have to file once. After it is approved, the exemption remains in effect for as long as you own and occupy the home. The application usually costs nothing and takes about 15 minutes to complete. On top of the basic homestead exemption, many states offer additional senior exemptions in the year you turn 65. These can add another $5,000 to $15,000 in total lifetime tax savings, depending on where you live. Almost no one who qualifies for these senior exemptions actually files for them because the county does not mail out a notice announcing that they exist. You have to know to ask for them, and now you do. Here is what you should do this week. First, locate the deed to your home. It is probably in your filing cabinet, safe deposit box, or available through your county recorder's online system. Second, make a list of which of these 6 documents you already have and which ones are missing. Third, for each document you do not have, search its name along with the name of your state. Read the first 3 search results. Fourth, call an estate planning attorney in your county and request a 1-hour consultation specifically about documents that protect your home. Expect to pay between $200 and $400 for that session. During that meeting, the attorney will explain which of these 6 documents you actually need based on your state's laws, your family structure, and what your home is worth. Fifth, do not delay. Every single one of these documents is time sensitive, and each window slams shut the moment something happens to you. Once you are in a hospital bed, once the court steps in, once a state agency gets involved, none of these forms can fix the situation.